Good day, distinguished judges and fellow participants. We are honored to present our research entitled The Contestations of Cryptocurrency Legitimacy as a Zakat Instrument within the Framework of Islamic Law and Indonesian Legal System. In today's rapidly evolving financial landscape, cryptocurrency has emerged not only as a digital asset, but also as a potential medium of wealth. This phenomenon invites broader legal and theological questions like how cryptocurrency becomes considered a legitimate object of zakat within the Islamic jurisprudential framework and under Indonesia's positive law. Our study seeks to unravel these intersections where the immutable principles of Islamic law encounter the dynamic nature of digital economics.
The background of this study stems from a fundamental dilemma. While Islamic law emphasizes the purification of wealth through zakah, the classification of what constitutes wealth or amal remains subject to interpretation. Traditional forms of zakah are well defined, such as gold, silver, livestock, and trade commodities. However, cryptocurrency challenges this definition. It lacks physical form yet possesses undeniable economic value and market circulation. In Indonesia, the existence of Law Number 23 from 2011 on Zakat management and the regulation of digital assets by Bapepti revealed the dualistic legal tension, the coexistence of religious legitimacy and state regulatory recognition. To explore this issue, our study employs a normative juridical method, focusing on doctrinal analysis. We examine primarily legal materials such as the Quran, Hadith, fiqh interpretation, and national regulation concerning zakah and digital assets. This is complemented by secondary sources including scholarly articles, fatwas, and economic reports, allowing us to construct a coherent framework of argumentation. This method enables us to bridge theological reasoning with the positivistic domain of Indonesian law. Our finding reveals that the legitimacy of cryptocurrency as zakat instrument lies in a state of contest of validity between two systems of thoughts. From the Islamic legal perspective, certain scholars accept cryptocurrency as mal mutakawim or a lawful property with measurable value, thus potentially eligible for zakah. Yet others reject it due its volatility, absences of intrinsic value, and speculative tendencies, which may contradict the Maqasid al-Sariyah principle of his al-mal, the protection of wealth. Meanwhile, under the Indonesian legal framework, cryptocurrency recognized as tradable digital commodity, not a legal currency. This recognition creates a regulatory paradox. The state permits its trade, yet does not acknowledge its standard unit of value in religious obligation. Thus, the crux of the issue lies not merely in legality, but in legitimacy, whether cryptocurrency fulfills both the moral and structural criteria of zakatable asset.
In conclusions, our study highlights that cryptocurrency's status as a zakat instrument remains contested, neither fully accepted nor explicitly forbidden. The path forward requires an integrative jurisprudence, one that harmonizes the elasticity of Islamic law with the evolving realities of digital economics. Therefore, policymakers and religious scholars must collaborate in formulating adaptive legal frameworks that ensure the spirit of zakat, justice, purifications, and social welfare remains relevant in the digital era. In essence, legitimacy is not found in the medium of wealth itself, but in the ethical consciousness of its owner. So, thank you for your attentions. We are Dina and Giara, and has been our presentation on the contestations of cryptocurrency legitimacy as a zakat instrument within the framework of Islamic law and Indonesian legal system. Thank you.